my employees, we're working together, but unfortunately, something happens. One of the employees is involved into a misconduct. Misconduct, and you mean they're stealing, or they're coming in intoxicated, or they're unable to do their jobs based on one reason or the other. So perhaps you can take us through some of the disciplinary procedures and measures employers need to abide by before terminating an employee.
Right. So before you can even allow your employees to make such offenses or misconduct, it is usually recommended that you at least have a HR handbook or an employee handbook that explains your guiding principles as a business, as a company, as an employer. And it outlines what constitutes offenses to you as an employer. So it has everything to do with reporting time, to do with disciplinary measures on intoxication, maybe there was violence, things like sexual harassment. So it becomes a guiding book for your employees.
So like a Bible?
Yes.
Okay.
So even before you start this, coming up with disciplinary measures and you're coming to discipline them, at least you've already taught them or you've given them some sort of guide so that they are aware of what they are allowed to do and what they are not allowed to do.
So do I have to train the employees?
Yes.
On this handbook?
Yes. So of course, as an employee, and it is recommended that at least you do it once when you are onboarding this employee, that you give them a copy of that HR or employee handbook or manual.
Okay.
You can train them, give them a chance to ask questions, give feedback, and then at least once every other year, or at least once every year actually.
Okay.
Just make sure you touch base, retrain, in case maybe you've added new things or you've changed or you've amended the manual, then you let the employees know, you train them so that you make sure that everybody is on the same page. Now, for most companies and most businesses, these employee handbooks will also have sort of a guiding outline on how disciplinary measures are taken. So you might find if you come in late more than twice, you'll be given a verbal warning the first time, and then you'll be given maybe a month within which to improve. If you don't, you're given maybe a first warning letter that will be in writing. Then maybe you're given another 2 months to improve. If not, you're given a second warning letter. Then perhaps finally you might be terminated.
Okay.
So the employee handbook or manual can be a guiding, but of course at all times this employee handbook and the disciplinary measures that you employ as an employer or as a business owner must always be in compliance with the Employment Act. So maybe sometimes you might find there are cases of stealing and you need to do investigations. So as an employer, you are allowed to suspend an employee. However, you still need to pay them their full salary and allow them to enjoy their full benefits. So of course you can do this, you can write them a letter, perhaps tell them that there was this offense that was reported to you as an employer and you need to carry out investigations, and for the purposes of these investigations, perhaps you need to put this particular employee on suspension for a number of months. However, like I said, they still need to receive their full salary and their full benefits. Then at least you have enough space and you have enough time to then conduct these any investigations that you want, and then depending on, of course, the results or the outcome of the investigation, the employee can either be exonerated, I don't know what a simple word, found innocent, or maybe they are found guilty and you now need to go into the termination process. So but as always, you need to at all times give notices to the employee. The employee needs to be aware what is this that they are being accused of, so that they also have a chance to also prepare their defense. Some serious offenses you might also need to report to the relevant legal authorities, perhaps the police. Surprisingly, offenses such as intoxication, that is again another very long topic, Someone can come in and they look intoxicated, but maybe to them that is when they're now very able and very capable to do even work for two people. Now, unfortunately, courts, and when you go to court and you've terminated someone on the grounds of disciplinary such as intoxication, you still have to prove that they were indeed intoxicated, and because they were so intoxicated, they couldn't carry out their responsibilities. So for things like intoxication, unfortunately for you as an employer, you might still need to make sure that this employee is taken through some medical tests to actually confirm that they are indeed intoxicated.
Wow.
Some courts recommend, of course, even in cases of intoxication, if your company can or has a budget, I've seen some companies take their employees for therapy.
Yeah, rehab.
Yes, or sure. rehab for such cases and measures.
So, okay, now I've done the investigation as an employer, and I've sent out the notice of the result of the investigation to the employee. So, what do I need to do before I terminate the employee? Can I just wake up and say, they're guilty, go, leave the company? Or do I need to do any hearing before I terminate the employee?
Now, I think the stickiest situation that most employers face is when it comes to disciplinary and termination.
Okay.
And like I think we've said in previous videos and articles, as most times, 99% of the time, the employment courts will always be pro-employee.
For sure.
Unfortunately, that is just how things are with the court.
Unfortunately, depends
on
the side.
Depends on which side you are on, and as a lawyer, I mean, of course, who you're representing.
For sure, yeah.
So when it comes to termination, there are two aspects. So you need to have good grounds, but you can have good grounds, but you've not followed proper or due procedure. So you need to have good grounds for termination, and you also need to follow the procedure as per the Employment Act.
Okay.
Now, the Employment Act, of course, I know provides for something called summary dismissal.
Yeah.
And I know most employers really enjoy that summary dismissal when it comes to, of course, certain cases that are outlined under the Employment Act. However, we've seen in the recent years, again, most courts leaning towards, even though there's this specific provision for summary dismissal, you still have a right, or rather the employee still has a right to undergo the entire termination proceedings. They still have a right to be heard. So technically you can't just summarily dismiss. So you need to do the entire process. And what is that process? So of course, again, you need to give notice in writing to this employee. You need to outline what is this you're accusing them of having done.
Yeah.
And then you need to, of course, call them for a meeting. So in that notice, you let them know that they can come in for a disciplinary hearing on a particular date, at a particular time, at a particular hour. And as the employee, they also have the right to come in with a representative of their own. It can be, if they're unionized, they can bring a representative from whatever employee trade union they are under or in.
Okay.
Or it can even just be a fellow employee who can come in as a witness. Of course, it is recommended that you give them such notice early in advance so that even they have a chance to prepare for their own case. In case they need to gather evidence, they can do that. In case they need to rally up witnesses, they can do that. Of course, you need to also give them an opportunity to respond in writing. And then during the hearing, of course, they can also again give their side of the story, which of course as an employer, I know most times you don't want to hear it, but maybe they have good grounds, or they have actually just something like a reasonable excuse, or reasonable grounds, or a reasonable, okay, at least a reasonable explanation.
Yes, of what happened.
Yes, of what happened. So you as the employer during the hearing, of course they'll be there, you'll be there. They can come with their witness of their choice, and you just give them an opportunity to defend themselves. Of course, it is always recommended that you take minutes of these hearings, because in case anything goes left or you are sued, then you have proper records. Otherwise, it's going to be a he said, she said. And then, so just weighing, maybe you've done your investigations, weighing the evidence, you can now decide you want to terminate. So of course, when you're terminating, again, you need to give them written notice. In case there's any salary or any benefits that are owed to them, then they need to be paid. You need to make sure when you're terminating them, even you as the employer, their NSSF, their NHIF, their pay is also up to date. Because we've seen cases where employees go to court,
for sure,
to demand and say my employer was not paying my pay, was not paying my NHIF, was not paying my NSSF.
The deductions, all right. Before we go to the deductions, do I have to sign the minutes, or as an employee, should I sign these minutes?
Yes. So of course, so it is recommended, of course, the employer is the one who will take down the minutes of the hearing.
Okay.
Then once you've taken down these minutes, you need to share a copy of these minutes with the employee, just so that they can confirm that is a true reflection of what happened during the meeting. And then you sign a copy, or rather you sign on a copy, they sign as well. They get to keep a copy as employees, and you get to keep a copy. Now, if they refuse, sometimes they refuse to sign just because, you fired me, I really don't want anything to do with you. Of course, you can't force them to sign, but at least make sure you've shared a copy of the minutes of the hearing.
All right. So, as we pay the deductions, and we're also remitting your salary to you upon termination, what other allowances or other payments should I as an employer make to the employee as I'm terminating them?
Right. So the most common one is usually pending leave days. So you'll find maybe you are terminated and you hadn't taken your full 21 days of leave. So if you hadn't fulfilled or you hadn't been able to take your full 21 days of leave, then the employer has an obligation to make sure that they pay you for whatever leave days are remaining. Then, depending on each organization, maybe there were some other special benefits or allowances, maybe there was some travel allowance. Now, these are not statutory deductions, or they are not there in the law, but maybe they were there in your contract.
Okay.
So some of these payments will also be determined by the contracts and what are the terms of the contracts. If this employee has worked with you for at least a period of 1 year, then you also need to give them something we call a certificate of service. You don't need to speak into their character, whether they were good, whether they were bad, whether they were excellent, whether they were a thief or not. It's just to say that you confirm that this person worked in your organization under this position for this number of years. Because they're also entitled to that under the law upon departure or upon termination.